In a prior blog, I spoke about the game-changing effects of Papadopoulos v. Target Corporation, and that's in the context of snow and ice cases in Massachusetts. Until Papadopoulos, that is until July of 2010, we had to say that what occurred was the result of an unnatural or artificial accumulation of snow and ice. This posed a lot of hazards, if you will, to plaintiffs and plaintiffs' practitioners. However, the Supreme Judicial Court in that case in July of 2010 changed things and said that no, a landowner where there is an allegation of a fall on snow and ice has the same duty that a landowner would in any context. That is a duty of reasonable care. And a lot of attorneys, myself included, breathed a sigh of relief over that. So, having recently had a few successful, I'm happy to say, mediations of snow and ice cases, I thought I would discuss with you the common themes and what makes for a successful snow and ice case, and at the very least, what are the issues that come up. First, I would point out that we're in a post-Papadopoulos world, so again, you do not look for the dripping water from an awning or a defective gutter. Granted, if you have that, that's so much the better, but if you don't have that, that doesn't end the inquiry in terms of your case. Secondly, you want to get the weather records. Thirdly, you want to see to it that the accumulation of snow and ice or precipitation had concluded before your client had gotten hurt, before the plaintiff's accident. Why? Because in the exercise of reasonable care, the landowner or other person or entity in charge of keeping the premises safe would have had an opportunity, a sufficient opportunity, to clean or treat the area. That's why the weather records are so important. And again, you can see that we're focusing on reasonable care. If, on the other hand, a storm was in progress, then it would be unreasonable to expect the landowner to take care of the precipitation that was coming down. Key case from the 1970s is Wexler v. Stanetsky Funeral Home. And in that case, people were coming to this funeral home and tracking in ice and tracking in water, and the plaintiff fell in the entrance to this home. As a result, the court said, no, this is a storm in progress and no landowner can be expected to guard against that. So that's an issue that can come up, and an issue, hopefully, where the facts are in your favor. It always helps, as in any case, that you have a good client and you have defendants on the other side. I notice I said defendants. It is better to have a joint tort situation. Typically, it is better for the plaintiff. And in it, the relative degrees of fault do not matter. But if there is a finding of liability, each is jointly and severally liable for the plaintiff's damages. Of course, we still look at the comparative negligence of the plaintiff. But in that joint tort situation, you will have two defendants who would be charged with taking control and care of the property. And again, in that Papadopoulos situation, the court looks to the availability of snow blowers and machines to treat sand and to treat ice and snow and salt and sand, and the court even uses language that a landowner armed with a sufficient supply of such things can be expected to take care to remedy that situation. And finally, I'll say with respect to snow and ice cases, if the person who was hurt lived at the property or even was a guest of the tenant of the property, a breach of warranty is permitted. Now, a breach of warranty has to be based upon a violation of a sanitary or building code provision, and there is such a provision. 105 CMR 410.452 obligates a landlord to keep exitways, stairways free of snow and ice. And increasingly, courts are instructing juries, and that can go towards the breach of warranty, and it also is evidence of negligence if they did not adhere to that requirement. Thank you.